Good morning.
Good morning.
Good morning.
Good morning.
早上好。早晨。Thank you, Nancy. Thank you, everybody, for coming. I know you're not coming for me. You're coming for somebody else. But it's a great honor to be here once again, to be with you. Because I see the respect. Am I using the mic correctly or I'm missing something? No. Hello?
Yeah.
All right. Now, like I said, I appreciate the warm welcome once again. I see the respect for knowledge. I see the respect to law and respect, and I see the respect for experience and the actual practice of law. And for that, I thank you very much. And I will do my best. I did my best for the past week in preparing for this little speech. I was told that I have very limited time, but I have quite a few topics to talk to you. But I will try to make it a condensed version, and hopefully in the future I can meet you guys again. Or if you have questions, you can always call me in my office or even at my cell phone. But don't call me at midnight. I have 4 kids. Well, the topic today I was framing it as real estate management, including UD. As you all know, what is UD? Unlawful detainer. It's a term in California for eviction, and it is a indispensable part of property management. Let me ask you guys, how many of you have ever managed a property? If you do, please, if you have, please raise your hand. How many of you have ever evicted a tenant? How many of you have been asked by your clients to manage their property? I see at least, if you qualify under these 3 categories, you have 90% have been involved in a real estate management unlawful detainer issue. So that's I can say it's a hot topic. And then I will talk about fraud prevention in real estate transactions and in real estate management. Let me see if I am able to use this correctly. So my name is Cheng. I'm a real estate attorney, and I'm also a real estate broker for many, many years. But I don't sell houses like you guys. That's why I'm very jealous of your jobs. It's always freestyle. You can wake up at 10 and make an appointment with client for 11. But we are set by court. Usually the morning session is 8:30. I have to get up at 6 and drive on the terrible freeway of 10. And you're stuck on the freeway for 2 hours. But you guys are great, and I had great experience working with the agents in St. Gabriel, especially the agents from St. Gabriel Board. Let's see. Okay. Of course, in property management, if you are managing, can I take this off?
Yeah.
Okay. So in property management, we can divide it into 2 categories. The first one is residential. For residential property management, it's usually less complicated, but the law holds the landlords to a higher standard for property maintenance. What is the standard? The standard is inhabitability. So the property has to be habitable for your tenant. Let's say your house doesn't have a roof. Is that habitable? It's not. Your house doesn't have hot water, or it doesn't even have a plumbing system. Is that property okay to lease? And what if during the tenancy, the plumbing system got an issue and your tenants could not get either hot water or cold water? So who is responsible for that? The landlord. And the tenant's rights to refuse to pay rent. We're going to talk about tenants' right to refuse to pay rent. If any of this inhabitability issue arises, the tenant might, listen very carefully, might have right to refuse to pay rent, but it is not a given. Your tenant cannot say that, hey, I got you, here's an issue, here's a bug, here's a mosquito that bites me in my mother-in-law's arm, and she is complaining a lot of pain, I'm not paying rent. That is happening as of today. I have a client who is complaining to me that his tenant is not paying rent because the mother-in-law had an issue with mosquitoes. I don't know if it's lying, but it's definitely an issue we can talk about. Okay, and we as we all know, that's the major reason for unlawful detainer action in California. That's how we should approach it. I'm going to do a case study, a sample case study. You will see from A to Z, from the 3-day notice to pay rent or to quit, till the end, till the sheriff's eviction of the tenant. Everything is an actual case, but I deducted the actual party's name, and you will have a full view of a real case. As to commercial real property management, usually it's more complicated, including the lease contract. You want to talk about different terms of lease. Is it gross? Is it triple net? You also want to talk about HOA with your tenants, making sure that they understand what they are leasing, what they're getting, and what you're giving. And of course, you would also take into consideration of the federal law compliances, including the ADA compliance, federal taxes, state taxes, operation expenses, management expenses. You have a lot of disclosures, and you have to make sure that there is a meeting of minds. Of course, once it is leased, the commercial landlord might have a lesser responsibility. Let's say you listen to your tenant, your tenant is running a warehouse in your property. 2 months later, there was a leaking in the roof. But at the time you lease the property, you list it as is. Does your tenant might have a right to refuse to pay rent as a residential tenant? The answer is no, because you list it as it is. And let's say that there is a robbery on the property. This might be similar to your actual case, because this case, the agent is from our board. Okay, but I'm not talking about your actual case, but it's similar. If there's a robbery in your warehouse, is landlord responsible? Does the tenant have the right to refuse to pay rent? Yes or no? There's no, it depends. Okay. And in law, I mean, if you been to law school or you have been involved with law, when you ask a question to your lawyer, the best answer is, it depends. Okay. It depends. Let's say in my case, there are 3 prior robberies on this exact premises, on this exact warehouse. And the landlord, if the landlord didn't disclose, here is an ongoing criminal investigation on our property, go ahead and rent it. And then when tenants ask, hey, this area, this place or this area is famous for some criminal activities or grand theft. Do you have any experience in your property? What if the landlord said, no, don't worry about it. My property is super safe. It's as safe as White House. And then 2 months later, robbery happened. Do you think that there is a cause of action for the tenant as well? So what I'm saying, I'm not telling you that's the real case, okay? As somehow similar. What I'm telling you is that the answer is, it depends. It depends upon the facts. It depends upon what the landlords and tenants have agreed to. If the landlord has been intentionally kept material information from being disclosed, either by himself or by his agents. So as agent, we should be very careful. You always get what is it in your listing? You put up a disclaimer. All information you don't guarantee the authentication or genuineness of this information. You obtain it from public record, and a buyer or seller is supposed to get information from his own source. So that's a good protection. The same thing, you would also get the similar thing from your client when putting up the information. Don't represent anything without your client's confirmation, either in writing or somehow in some kind of evidential method. A text message is admissible in court. Like an email is good. So that's something we're going to talk about later. Okay, a typical unlawful detainer flowchart. Well, first, before I get to the real case, I want to give you some idea. Can I put it on this? In California now, since 2012, the court has divided into several hubs. So you cannot file unlawful detainer in an eviction case in Alhambra, can you? No. You cannot file an eviction case in El Monte, can you? No. You used to be able to, right? Yeah. But after 2012, when California was going through some financial difficulties for judicial systems, so they kind of put all the court systems into several hubs. So now in California, we have, in Los Angeles, we have, we have 9 hubs for unlawful detainer action. What we are, most of the times, we are using several court around us. First is Pomona, second is Pasadena. The courthouses I went very often, Pomona, Pasadena, Long Beach, Santa Monica, Norwalk. There are differences in filing at the court. Sometimes our agents are very intelligent. They found that I have to file an action to evict a tenant. So they file the case, they go to Pasadena because the house is in West Covina. Is that a right choice? Why?
Because it's Pomona.
It's Pomona, yeah. He filed it in Pomona.
Yeah.
Is it absolutely correct to file it in Pomona?
No.
Why not?
To
file what?
In LA.
Oh, yeah, you can file in LA, but can he file in Pomona?
Sure, you can file.
You can file in Pomona as long as it is unlimited jurisdiction. If it's limited jurisdiction, you cannot file it there. You file it in Pasadena. So I'm going to give you some free court flyers, court decisions as to where to file. If your case is about, rather than a possession issue, you're only suing your tenant for $2,000 unpaid rent. And some cost, expenses, let's say $600, $2,600. Can you go to Pomona and file it in unlimited jurisdiction?
No.
You cannot. Let me give you a brief idea as to what is unlimited jurisdiction. Any monetary claim that's over $25,000 is called unlimited jurisdiction. 25, magic word, magic number. Anything below 10,000 is small claim. Okay. Anything between 10,000 and 25,000, we call it limited jurisdiction. But in unlawful detainer action, anything below 25, we categorically call it as limited jurisdiction. So if your claim is very little, you go to Pasadena. If your claim is over 50,000, you don't go to Pasadena because you're not going to get the full jurisdiction amount. You're going to get the, you have to go to Pomona. Okay, so the list of the courthouses, the limit, are all listed in a court, in the Superior Court of California for LA's order dated December 31st, 2014. I can spread that to you if you can provide me with your emails or other contact methods. Now, I can't really see the chart. Can you enlarge it, or is there any way I can do it? Okay, this is a okay. Oh, good. Oh, I need to see the top. This is, everybody can evict a tenant. You don't have to be a lawyer, but you have to be very, very correct and very accurate in the procedures and in the notices. Those are very technical things. They are standard, but you have to be very technical. One word missing or one term missing, your case could be totally overturned. You might just waste your 2 months' time, and you will lose in the trial, or in a demurrer of a motion to strike or motion to dismiss. Let's see. It's the first thing you're gonna get. Let's say if your tenant doesn't pay, the first thing you would do is a what? 3-day notice. It's a 3-day notice. I can't see the chart. If I may, I will approach it closer. So it's a 3-day notice. In a 3-day notice, you need to be very careful. You always want to name the contracting tenants. You want to put their names on. Let's say Jack and Jill are the tenants. Are you going to name only those two in the 3-day notice? No. Who else are you going to name? All unknown occupants. Okay. Oh, you don't use those because there's no action filed yet. It's a legal term, okay? Those is usually you will file it in the court. You want to name it in the action, but not in the 3-day notice. So you would name Jack and Jill and all unknown occupants at the premises of Good Luck, 123 Good Luck Road in Good Luck City, California. Okay, and then you're going to serve. Usually, if you are the owner or the agent, you can serve. But the method of serving a 3-day notice is very confusing. Some people just go ahead and post on the door, even though you can see the guy is smoking a cigar, drinking a crow in front of the porch. He don't give it to the tenant. He just go ahead and post it on the gate, and then go to court and say that, oh, I served a 3-day notice. Do you think it's good? No. So the first thing you would do is the first choice of service of legal documents is presented to the tenant in person. However, if he's not there, you knock on the door, there's nobody there, you can post it on the door. Okay? If the guy might say that I was there, I saw him, he dropped something on my door, I don't know what it is. So you can claim that there's no 3-day notice served. And then once the notice served, you can prepare, your server can prepare a proof of service, and then put it on file in case the eviction case would have to be formally filed. So with 3-day notice, you would see, can I point with the pointer?
Sure.
Back to your PowerPoint?
No, I want to use the laser pointer.
Laser light.
Is this the laser light?
We don't have one.
Yes? No, okay, never mind. Never mind. Okay, so either a tenant pays for the rent, so the case is resolved, you're happy, he's happy, everybody move on with his life. Now, if he does not pay the rent, and then you need to move on with your unlawful detainer action. And in action, a lawsuit always starts with a summons and complaint. So you go to court and file a summons and complaint. I will have samples for you. You would be able to see the actual summons and complaints. And you would have to get somebody to serve the summons and complaint. The service of summons and complaint is different from the service of 3-day notice. The landlord can usually serve the 3-day notice. However, the landlord usually, we don't recommend to serve the summons and complaint. Why? There's obviously a bias, or there is a conflict of interest. You cannot say that I served my own lawsuit against the opposing party. It creates some issues. So you always want to find a person of 18 years old who is not a party to the case to serve the summons and complaint. You can find an attorney service for $75 or $65, it depends. And then you serve the summons and complaint to the tenant. Here it's very technical. You cannot simply post the summons and complaint on the door, even if you knocked on the door. You have to, first choice, you have to serve it in person. Hey, tenant, here's a summons. You're being sued by, Donald Trump. Say, here's the lawsuit. You gave it to him, lawsuit served. But if you want to post it, there is an option for a lawful detainer action to be posted. You have to go to court and get an order. Okay? Don't simply post a summons or a summons and complaint on the door and go to court and judge, I've served the summons and complaint. 100% you'll lose on a motion to quash service. And then you have to do all this all over again. It's a waste of your client's time, and it's a waste of your time and money. It costs money. So make sure that your proof of service is correct. Find the right person. Now, you sue the tenant. What is going to happen? The tenant might say that, forget it, I can't pay it, and I will just wait until see what you can do. So the tenant didn't respond. Look at the left side. You'll see that the tenant doesn't respond. And the next day, you can go to court. You have 5 days. The tenant has 5 days since service to file a response. Remember, response doesn't have to be an answer. If he is able to afford a lawyer, his lawyer might look through the complaints and say that this is deferrable action. I'm going to file a demurrer. Usually a demurrer would give him another 15 to 20 days. It depends upon the court calendar. The court might see, oh, this demurrer, we're gonna hear it in 20 days. So 20 days you have to file this. You have to go to court and see how court would rule on this demurrer. Usually a lawyer would just say that let's just change the complaint and see if we can meet we can fix the issues in the complaint. As to several typical issues in the summons, in a UD action, I will show you some examples, so you have a better idea. So they respond. Another option is that they can file motions. Let's say that in your lease contract, there is no attorney fee cost. Some people just write a note. Hey, Jenny, I rent your house for $500 a month, and the rent is due on the first of each month, and 10 days after which would incur $50 penalty. But there is no other terms. But you go to court and you sue me, other than claiming the monthly rent or back due rent, you ask me to pay your attorney's fee in the amount of, let's say, $4,000. At this time, I can go to court and file a motion to strike. A motion to strike usually can give me 10 or 16 days, 10 to 15 days. Guess what? I would win because under contract law, if there's no attorney's fee, you cannot claim attorney's fee. That cause of action, that claim could be stricken by the court. So you waste your time. You have the better choice is taking that section out. You have to eat up your own attorney's fee. Understood? So there's a default. You go to court and you ask for a default judgment. You get a judgment and take the judgment to the sheriff. The sheriff is you're gonna get a writ of possession. You're gonna evict the tenant. However, look at the middle line. The tenant is gonna file an answer. So during filing the answer, then there's some time. It depends what you would do. During that time, you can do discovery. A lawful detainer can do discovery. Okay, it could be very complicated. You can serve a notice of deposition. You can take a deposition of a third party, and you can send out written discoveries, including a request for production of documents, a request for admission, and form interrogatories and special interrogatories, all those discovery instruments that you can use. And then, as a landlord, you need to go to court and request for trial. You don't sit there, file an action, and I'll wait for the court to give me a trial date. It's not like that. In normal civil case, you would go to court in a case management conference. The judge is going to talk to you about trial dates and final FSC, final settlement conference, and discovery cutoff dates. But in unlawful detainer action, you, as the tenant, as the agent, or as the manager, or as the landlord, have to go to court and request for a trial date. Can you scroll that down? Now, when the trial date set, then you prepare for trial, you go to court. Some agents, some brokers here even called me and asked, well, what should I do in court? Why I have presented my case, but the judge still, I cannot get the tenants out. What is the reason? I said, you might not, you might have missed something in the trial presentation, and you might have missed some request. If you didn't request some remedies, let's say that you didn't request to remove all unknown tenants, unknown occupants in the premises. You can remove Jack and Jill, but you cannot remove my grandpa. Because you didn't sue them. You didn't give them notice. You didn't allow the opportunity to claim possession at the time you filed the lawsuit. And you didn't ask the court for the relief. So the court is not going to volunteer you. So, hey, Jenny, you're so nice. I'm going to offer you a remedy, a judgment for you to evict Jack's grandma or grandpa. No, you're not going to get that. I have a complete list questions for you to ask your clients, the landlord, in court. The reason I only brought the questions for landlords is I think you would only represent the landlords. You would not represent a tenant. So those would be helpful for you. The complete questions, one by one. Let's say, what is your name? When did you sign the lease? Those are helpful. I will give it to you for any time, and as long as you provide me with your email. I'm very time pressured. Now, I am gonna run through the sample case that we have been. Can I go to the PDF? It's going to be very quick. Can you help me scroll down when I'm... So this is a sample 3-day notice. Look at the red line portion. Why I redlined it? Because I said all other unknown, you can say all other unknown occupants of the premises to describe below. Here is a premise. This case happened in Santa Ana in 2014. Go down, so you ask for how much rent is back due, and you tell them that you don't pay to Jack Cheng, we're going to file the unlawful detainer action, and go all the way down. And if you are a business, you're a management company, you have to provide a work hours, a business hours. Otherwise, the tenant might say that, hey, I came and nobody was there. So this is a proof of service. You have to say on this day, I served a 3-day notice to pay rent or doing this and that by personal delivery to the tenants. Or just scrolling down, and you would have to have someone sign it. You have to declare under penalty of perjury of state of California, this is true, I served this, go all the way down. So here's the summon. Someone cracked when he said that when you file the lawsuit, you have to sue Joe, can you go back to the top. So you sue those two contracting parties and those 1 and 10 to 10. If you may think that there are a lot of tenants, you want to go those 1 to 100. It's just up to you. Okay, go all the way. So this is the summon. You go all the way, go down, go down, go down. You don't sign on summons. Okay, summons is issued by a court. You don't sign at the bottom. Here's a complaint. So you file a lawsuit. This is a complaint. Go all the way, go down, go down. So you name it, you have to describe in detail as to what is the rent due, when was it due, and how much in total. Go all the way down. So this is a sample that you can compare. Go down, go down, go down. Yeah, it's quite a few pages. This form have not changed yet. So here, go up a little bit. So in unlawful detainer action, you usually want your landlord to verify it. So it's a verified complaint. Okay, go down. Here, this is the form that you serve to the unknown occupants. As I said, you sue Jack in jail, but you also serve a prejudgment claim right to possession to the unknown occupants. This is the form that you have to attach it with your summons and complaint. So I give it to you. If anybody claims that he is occupying this premises, he or she has to sign this form. I give you an opportunity to claim possession so that I can sue you all together. Okay, this is the form. Go all the way down. It's going to be very quick. Can you allow me another 2 minutes?
Yes.
Yeah, okay, very quick. Go all the way. All the way down. So this is proof of service by court. Go all the way down. So go all the way down. Go down. So here, go back a little bit. So this is a tenant's ex parte application for stay of eviction. Some tenants may say, I want to file a motion to stay the action. They can go ex parte. Okay, they can go ex parte. Whether the court is going to approve it, let's see, the court denied his application. Go down. Go down. So this is our opposition to their motion. So we won the motion, and the court said that we're going to have a trial. Of course, we had a trial. We'll win the case. Here's the judgment. Can you go here? So this is the actual judgment. So you win the case. The court is you're going to prepare a judgment for the court to stamp, and you take the judgment to the sheriff. Go down. Okay. So you serve it. This is a. However, when the sheriff had the judgment, who was trying to evict the tenant, they filed for bankruptcy. When he filed for bankruptcy, what's going to happen? Yeah, the eviction stopped. Then what would you have to do? You have to go to court. So I filed a motion for relief from the automatic stay in bankruptcy court. And again, we won a motion. And the judge allowed us to continue to evict this tenant. So you can go all the way down, and you will see an order from the court. And then go up a little bit. Go up a little bit. Go up. Go up to the questions for trial. Go up. Oh, there's a questionnaire maybe at the bottom. So those questions are for the landlords to ask the witnesses, or for you to ask your landlord when you are presenting the case in trial, the actual questions. So those might be helpful for you. I was gonna go back, if we can go back to the PowerPoint. There is some points for you to prevent fraud. Go to the second page. Second page. Second. Up. Okay. As of course, you want to know how to prevent fraud. You would probably remember one key thing is statute of fraud. Put everything in writing, because statute of fraud in California requires you to put all transactions or communication in writing, keep good paper trail, documentation. Once there's a dispute, you can have some record to trace. I have all this handouts. I can email it to you or provide to you in some other manner. Time is running out. I really have a lot to share with you, but hopefully next time we'll have more time. Thank you very much.